In a hushed federal courtroom, the atmosphere itself seemed to tremble. The gavel came down sharp and final as Judge Beryl declared, "Congresswoman Crockett, you will not transform my courtroom into a stage for politics." A charged hush descended, as though the entire country paused to listen in that exact moment. Yet there stood Jasmine Crockett, steadfast and immovable like a boulder against a surging current. She refused to yield. She refused to submit, her gaze locked on the bench, and in a voice steady and resonant, she addressed the judge and all who heard, "Your Honor, with all due respect, the Constitution does not stop at your bench." This went beyond a mere personal dispute. It surpassed a straightforward legal debate. It represented a fight for the essence of American democracy, a direct clash between entrenched power and a bold new generation unafraid to demand accountability from authority. And friends, before we explore this extraordinary event in greater depth, I invite you to subscribe, become part of this community, and hit the notification bell. Because here, we don't simply watch history unfold, we analyze it, we embrace it, we experience it fully. The federal courthouse in Washington had seen historic moments before. Its sturdy walls echoed with passionate arguments, groundbreaking rulings, and the determined strides of attorneys carrying the burden of the Constitution. But on this particular day, a unique tension filled the space, one that no one in attendance would soon forget. The public gallery was filled to capacity. Journalists packed the rear seats, notebooks poised, devices humming with incoming alerts. Shoulder to shoulder were seated advocates for civil rights, their eyes fixed forward. Law students leaned in eagerly, scribbling notes not only of the spoken words but of the raw intensity of the emerging conflict. Overseeing the proceedings was Judge Beryl, aged 63. Her silver hair gleamed under the courtroom lights, her steel-gray eyes keen and piercing. A longtime member of the federal bench, she was renowned for her rigor, her intolerance for perceived showmanship, and her firm commitment to maintaining order. For more than 10 years, lawyers entering her domain anticipated not leniency, but strict control, abrupt interjections, blunt comments, and the unyielding pace set by her ticking clock. To many, she embodied the traditional establishment, the prestige of the judicial robe, the gravity of long-standing custom, the formidable presence of the system itself. Yet facing her directly was an individual cut from entirely different cloth. Jasmine Crockett, the Congresswoman from Texas, a former civil rights lawyer now in elected office, forged not in elite academies but in the hard-won battles of community-based legal struggles. At 42, she embodied the passion of a generation that had seen injustice up close and vowed never to remain quiet. Her natural hair, her crisp navy suit, her composed stance, each element conveyed not mere fashion but deep meaning, a testament to a life marked by perseverance and defiance. And friends, when these two forces met in that chamber, the realm of established judicial might and the realm of relentless civil rights commitment, the resulting sparks kindled a powerful blaze. The matter at hand concerned recently enacted election statutes, provisions that limited early voting periods, narrowed mail-in ballot options, and imposed stricter identification requirements. Proponents labeled them measures for election integrity. Detractors named them tools of voter suppression. For Judge Howell, it remained a purely legal issue, interpreting statutes, applying precedents, defining the scope of legislative power. For Congresswoman Crockett, it reached far deeper, touching the vital core of democracy. As she stood to address the court, she brought not just her legal filings and supporting studies, but the burden of entire generations barred from voting, muted by procedural hurdles, denied at polling places. "Your Honor," she started, her tone firm and even. "These statutes attack the bedrock of our republic. They do not bolster democracy, they choke it." A wave of murmurs rippled through the spectators. Journalists wrote rapidly. The judge's gaze sharpened. The conflict now stood in sharp relief. Judge Howell leaned in, interrupting the Congresswoman's remarks like a swift cut. "This court will not tolerate political rhetoric. Stick to the law." It marked the initial interruption, abrupt, rejecting, intended to rein in Crockett. But Crockett remained composed. She rearranged her documents, held the judge's stare, and continued, referencing prior cases, drawing on constitutional foundations, offering not only advocacy but proof, graphs, statistics, historical background. Once more, the gavel struck. This is a courtroom, not a seminar on history. The second interruption came stronger, more insistent. Tension gripped the gallery. Legal experts murmured among themselves. Civil rights attorneys shared glances of recognition. They had encountered resistance previously, but this seemed unique, a building tempest, pressure mounting. Yet Crockett advanced undeterred. Her language grew more precise, her delivery steady. She invoked the 14th Amendment. She discussed equal protection. She referenced the Voting Rights Act not as distant doctrine but as an active safeguard. And then, friends, the pivotal instant came. The gavel crashed down. The judge's words resounded through the room. Enough. Congresswoman Crockett, I will not permit this courtroom to turn into political theater. The ensuing quiet was profound. Every onlooker edged forward, pulses racing, aware that the coming response would shape not just the proceedings' direction but possibly the enduring reputations of those involved. In that heavy pause, Jasmine Crockett's real resolve emerged. She rose straighter, and her voice, poised yet resolute, pierced the stillness. Your Honor, with all due respect, the Constitution does not end at your bench. With that statement, the very courthouse appeared to shift. The audience inhaled sharply. Journalists paused. The judge grew rigid. In that instant, the divisions were clearly marked. It ceased to be solely a legal debate. It evolved into a standoff between power and conviction, between the authority of the robe and the strength of deeply held principle. And what came afterward, friends, would reverberate well outside those walls. Crockett's bold stand would not merely test a federal judge, it would resonate throughout the country. The quiet following her words was not vacant. It was thick, vibrant, charged with anticipation. For a brief moment, the federal courtroom's air held perfectly still. Onlookers leaned ahead. Journalists halted mid-note, and Judge Beryl remained frozen, gavel still raised, as though stunned by the challenge directed at her. Your Honor, Crockett said again, composed and unflinching. The Constitution does not end at your bench. It wasn't yelled. It wasn't born of rage. It was delivered with precision, with respect, with the weight of someone who understood those words outweighed the robe, outlasted the gavel, predated the court. And friends, that marked the shift in the room. Judge Howell, accustomed to prompt compliance upon her corrections, now confronted a woman who refused to submit. Her tone sharpened like an edge. Congresswoman, you will limit yourself to legal precedents or face contempt charges. But Crockett, steady, advanced a step. Her stare fixed on the bench, her posture firm. Her words carried a power drawn not from status or office, but from fundamental truth. I am citing precedents, Your Honor. Brown v. Board, Harper v. Virginia Board of Elections, Reynolds v. Sims. Decisions this court cannot overlook, rulings where the Supreme Court affirmed that what some label politics is actually the foundation of constitutional law. The gallery murmured in surprise once more. Journalists' pens flew. Devices glowed as instant updates spread. For years, Judge Howell had curtailed attorneys with cutting remarks. But now, control of the room slipped from her. Crockett held the stage, and she continued. Your Honor, she continued, her voice more pointed, her phrasing exact. When you reject constitutional claims as mere political points, you do not protect the law, you undermine it. When you dismiss equal protection as irrelevant, you do not strengthen democracy, you erode it. And when you suggest that a Congress member oath-bound to uphold this Constitution lacks legal understanding, you do not preserve this court's dignity, you harm it. Each phrase struck forcefully. The room's energy crackled. This was no longer merely a legal setting. It had become a forum for ideas, a lesson in principles, arena for intellectual combat, and Judge Howell, after a lengthy tenure, was yielding territory. She stood from the bench, finger extended accusingly, cheeks reddened. Congresswoman, you will not instruct this court. But Crockett lifted her hand, open and steady, composed yet assertive. Respectfully, Your Honor, I am not instructing. I am reminding. Murmurs swelled. A black congresswoman facing a federal judge had just gestured as if to signal, hold on. It carried profound historical weight, rich symbolism, tied to the long-standing currents of civil rights struggle in America. And then, with the chamber again motionless, she spoke the phrase that would travel far beyond those confines. Article 1 of the Constitution created the legislative branch I represent. It established the judiciary you now occupy. We, as the people's elected voices, granted this court its power. And I am here today to remind you that such power does not elevate you beyond the Constitution. It obligates you to it. Friends, those words made the courthouse resonate. They transcended argument, they served as a fundamental lesson in government structure. A quick primer on checks and balances, delivered not by an academic but by a congresswoman fueled by real-world experience. For almost half a minute, stillness reigned. It was the profound quiet that only pivotal history creates, where all present sense a watershed. And when it ended, it burst forth dramatically. Journalists hurried out, typing furiously, speaking urgently into devices. Unprecedented federal court showdown. Civil rights lawyers nodded in amazement, murmuring they'd witnessed something unprecedented. Students noted frantically, aware they'd recount being present to future generations. Beyond the building, word spread rapidly. Online platforms ignited. In hours, millions viewed excerpts of the exchange. By evening, broadcast hosts looped the key phrases. The Constitution does not end at your bench. Groups acted quickly. The ACLU commended Crockett's protection of core rights. The NAACP deemed her response an essential correction to potential judicial excess. Even the typically cautious American Bar Association released a note, "Constitutional advocacy merits full consideration. Strong, professional representation fuels our democratic system." At the same time, Judge Howell's standing started to erode. The Association for Federal Judges faced a surge of formal objections. Experts in legal ethics penned articles debating if her repeated interruptions and tone had breached neutrality. But Crockett's prominence only grew. Segments of her remarks circulated in educational settings, aired on broadcasts, analyzed on legal sites. Scholars in law hailed it as exemplary advocacy amid pressure. Organizers viewed it as a turning point for election access. And everyday Americans, from homes across the land, recognized in her not only a legislator or attorney, but a true guardian of the Constitution. Friends, this wasn't simply the peak of a single legal fight. It ignited nationwide discussions on power distribution, democratic significance, and the bravery needed to confront those in authority. Yet the impacts of that day, for Judge Howell, for Jasmine Crockett, and for election rights in the U.S., were just starting to emerge. The instant the judge left the bench and called recess, the tension broke. The oppressive quiet exploded into activity. Journalists rushed to corridors, devices to ears. Civil rights lawyers conversed in stunned tones. Law students gripped their pages, realizing they'd seen an irreplaceable education. But the lasting influence of that exchange would show in effects extending far past the courthouse. For Judge Beryl Howell, consequences arrived swiftly and harshly. Once celebrated for firm control, her name now linked to terms like excess, haste, and partiality. Hundreds of complaints flooded in during the initial days. An ethics panel in the Federal Bar Association launched an early probe. Serious penalties seemed unlikely, but the investigation alone challenged judicial trust. More damaging were private comments from colleagues. Experienced judges suggested she'd overstepped. Her formerly solid reputation now bore fissures. For Jasmine Crockett, the outcome contrasted sharply. She headed back to Congress not weakened, but strengthened. In committee sessions, her inquiries cut deeper, her delivery more incisive. When executives evaded, she noted with wry sharpness, "I've already devoted an afternoon to teaching constitutional principles to a federal judge. If you believe your dodging will unsettle me, think again." That remark also spread widely. Peers applauded her determination. Party leaders praised her openly. Organizers sought her for events. Academic institutions invited her to speak. And crucially, regular people viewed her as a true advocate. Civil rights entities seized the opportunity. The ACLU, NAACP, Southern Poverty Law Center, all spotlighted Crockett's stand as inspiration. Contributions rose dramatically, in places multiplying fourfold quickly. Community groups incorporated her remarks into promotional materials. She rose in court, the messages declared. Now we rise in our neighborhoods. And it succeeded. Her bold act fueled wider efforts to protect voting access. In academic environments, instructors updated curricula. Constitutional studies added a fresh example, Crockett versus Howell. Learners examined her approach, delivery, accuracy, and composure under provocation. Practice court events incorporated similar setups. In lectures, educators spoke admiringly. What occurred was more than advocacy, it was public instruction. Democracy protected live. Meanwhile, ordinary folks discussed the event at home and on radio programs. Some hailed Crockett as heroic, a modern David facing judicial Goliath. Others faulted her directness as improper. Yet regardless of opinion, discussion surged on election access, constitutional boundaries, and judicial roles, topics dormant for years. For a public weary of political fatigue, Crockett's act brought refreshing focus. It offered theater, certainly, but also essential civic insight. It recalled that the Constitution remains relevant, active, vital. Inside the legal system, the event served as a subtle warning. Judges discussed privately matters of conduct, demeanor, risks of misjudging advocates. In training sessions for the bench, Crockett's statements emerged as examples, highlighting the fine boundary between command and overconfidence. Friends, this transcended a typical legal disagreement. It was an ember escaping stone confines. It influenced lawmakers, motivated organizers, transformed education, and disturbed the bench. Jasmine Crockett didn't merely prevail in debate. She altered the national dialogue. Still, as impactful as the event proved, its effects extended beyond people. They concerned the country at large. Because this encounter compelled the U.S. to address fundamental issues, what defines judges' appropriate part in safeguarding democracy? What occurs when core constitutional points are brushed off as partisan? And ultimately, who bears duty to recall that the Constitution serves the citizens, not institutions alone? These weren't queries for one venue. They were challenges the nation now confronted, issues shaping democracy's path forward. After the intense encounter settled, the country faced not only a ruling in one matter, but a reflection of its own character. The exchange had turned into a mirror for America's identity, conflicts, and global position. For numerous observers, it highlighted the core conflict between law as process and law as ideal. Judge Howell personified process, the keeper of structure, prior rulings, effectiveness. In her view, the court existed not for broad concepts or historical reviews. It served to interpret laws, eliminate distractions. But Crockett personified ideal. For her, the Constitution was a vital commitment born of hardship, designed to shield the weak from dominance. When she stated the Constitution does not stop at a judge's bench, she articulated what many felt, that democracy's protectors must exceed rule enforcement. They must preserve freedoms. And nationwide, individuals agreed. They recognized this concerned greater stakes, who determines democracy's definition. Internationally, the event echoed. Overseas media featured prominent stories. Analysts wondered at the open display. To partners, it demonstrated U.S. vitality. To rivals, it offered evidence of division. But in any case, global attention focused. And observers witnessed not fragility. They saw active engagement. They saw a country openly grappling, often painfully, with its values. And in that effort, they recognized something uncommon: democracy vibrant, flawed, yet bold in self-examination. Central was deep symbolism. A black female lawmaker, once a community lawyer, holding ground against a white judge representing institutional power. That visual held profound meaning, formed by ages of fight. In Crockett's steady gesture, echoes appeared of Rosa Parks, Fannie Lou Hamer, Barbara Jordan. And friends, that's the profound reason this event resonated. It wasn't solely Crockett against Howell. It pitted history against now. It posed the recurring generational query: who speaks when power exceeds bounds? Who recalls that law exists for citizens, not vice versa? In homes and lecture halls, the issue persisted. Did this signal a fresh beginning? Was Jasmine Crockett stand the ignition for emerging leaders ready to contest fixed authority? Or just an uncommon burst of bravery? Answers remained unclear, but certainty existed. The event left an imprint. It sparked talks not just on voting but on democracy broadly. And once ignited, such dialogues endure. Thus, friends, the future called, unknown, risky, yet promising. What followed wasn't fixed. It would form from our collective decisions. History isn't forged in one instant. It emerges in lasting resonances, in ongoing impacts long after the gavel sounds. In following months, judges nationwide observed. Bench education quietly added talks on poise and courtesy. Where firm corrections once faced no pushback, judges now chose phrasing carefully. The Howell case reminded that power requires balance with moderation. A robe confers authority, indeed, but not perfection. And as Crockett clarified, the Constitution constrains the bench as much as lawmakers. For Jasmine Crockett, opportunities expanded. She transcended Congresswoman status, she became emblematic. Requests flooded in. Her addresses attracted audiences. Her example showed bravery can thrive where law meets governance. Aspiring attorneys sought guidance. They found evidence one can be bold yet courteous, firm yet polite. And her phrase, "The Constitution does not end at your bench," turned into inspiration. The wider voting rights effort gained momentum. Funds increased. Participants grew. Rights groups added her example to instruction. Practice courts used the Crockett model. Instructors discussed the Crockett style. It concerned more than one person, it fueled a resurgence in advocacy. But honestly, challenges lay ahead. Triumphs met obstacles. For each receptive judge, others resisted. Democracy's path never straightens fully. It curves, falters, advances and recedes. Yet in those curves hides opportunity. As Crockett demonstrated, one clear, ready, principled voice can alter discussion's direction. It can make even the strongest hesitate. And there, friends, rests the true future. Not solely in judicial offices or legislative chambers, but among us. Democracy isn't guarded by positions alone. It's protected by people rejecting silence, insisting on responsibility, recalling the Constitution as ongoing pact. Crockett brought that reality to court. But will we bring it to our lives, neighborhoods, ballots? Democracy's tomorrow belongs not just to benches or capital. It belongs to citizens and their present actions. And thus, friends, we circle back to that quiet room, the gavel's ring, the intensity in Jasmine Crockett's gaze, and the defiant words that sounded like resistance's anthem: "The Constitution does not end at your bench." What started as conflict became a modern lesson. It recalled democracy isn't secure from written rules or standing structures alone. It endures only when power holders protect it, and when regular people require its protection. For some, that day's recall brings frustration. Frustration that a judge could reduce constitutional points to politics. That millions' access could be dismissed. For others, it's grief. Grief that into this century, we battle echoes of prior generations. But most of all, it's inspiration. Inspiration from Jasmine Crockett's firmness. Inspiration from her influence spreading. Inspiration because she proved resolve and ideal united can influence even inflexible power centers. The message stands evident. The Constitution isn't owned by robes, gavels, or grand buildings. It belongs to citizens, to you, me, everyone ready to safeguard it. And so I ask you, not as observers but as participants, does Jasmine Crockett's action signal emerging bold leadership, or a lone bright spot in a vulnerable framework? Please share your views in comments. This dialogue belongs to all of us. And finally, I encourage you, subscribe, engage with this group, and pass along this account. Because we go beyond witnessing history. We advance it. We uphold it. We ensure the Constitution endures. Keep this in mind: judges may bang gavels. Leaders may speak loudly. But America's real strength has always lain with the people. People who understand, as Jasmine Crockett showed, that the Constitution does not end at any bench.